Test 1 2, test 1 2, microphone check. Good morning, everyone. The time is 9:09. This is our first captions check for our YouTube stream. As a kind reminder, please remember to check the light that is on the microphone at the podium before you begin speaking. And before you leave the podium, please make sure to turn off the microphone as not to capture any unwanted audio, as I'm about to do now. Good morning, everyone. Mic check, 1, 2, 3. This is our final captions test for our live stream. Kind reminder, if you are using the microphone on the podium, just double check to make sure that the yellow light is on. And before you leave the podium, please push the button to make sure that it is off so that it does not capture any unwanted audio. We will begin shortly. We are now recording on both the camera and the back. That is a hot mic, so anything that is said near the camera will be recorded for backup record. Thank you.
Good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, July 17th, 2024, time's 9:30 a.m. I'm John Neerman. I'm joined today by Commissioner Caterina Gonzalez and our General Counsel, Mary Smith. Registration has now closed, but if you'd like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, your affiliation, or the item that you'd like to speak to, or if you're with us today, you can visit our registration table and we'll do our best to accommodate your request. For those who are addressing the Commission, our General Counsel or I will inform you of your time limits, and I want to thank you all for being present today. And Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application of the City of Houston for a major amendment to TIPI's permit number WQ 001-04-95030. The order of presentation will begin with the applicant, followed by the protestant, the ED, and then OPIC. Each party will have 5 minutes of oral argument time, and the applicant may save time for rebuttal as it bears the burden of proof on the application. And so we'll begin with the applicant, and I believe we have Mr. Philip Goodwin here with the applicant.
Good morning, Mr. Goodwin. Yes, sir. And check your mic and just make sure your light's on.
There we go. Thank you.
All right, we can hear you. Go ahead when you're ready, sir.
Good morning, Chairman, Commissioners, General Counsel, OPIC. I'm Philip Goodwin, Regulatory Compliance Director for Houston Public Works, Department of the City of Houston. I am here today in support of the ALJ's PFD in this matter, which would grant the requested permit renewal and modification to the City of Houston. And I'm here to answer any questions you may have.
All right, thank you, sir. I have none, Commissioner Gonzalez. I don't think we have any at this point. Thank you very much.
And next we'll have the protestant. If anyone is here, I don't have anyone registered for the protestant.
Is there anyone here protesting this, this proposal for decision? All right, let's move on.
So we'll move on then to the ED.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I'm Fernando Salazar Martinez of the Environmental Law Division, and with me today is Abdur Rahim of the Water Quality Division. The Executive Director agrees with the Administrative Law Judge's findings of fact and conclusions of law as referenced in the proposal for decision on the 3 referred issues. The ALJ found that the draft permit is adequately protective of water quality and uses of the receiving waters under the applicable Texas surface water quality standards, that the draft permit contains sufficient provisions to prevent nuisance odors, and that the proposed facility is located above the 100-year floodplain and is adequately protected as required by 30 TAC sections 309.13 H and I. The ALJ also found that the prima facie demonstration, which was established through the filing of the application, other sufficient supporting documentation in the administrative record, and the ED's draft permit and preliminary decision was not rebutted by the protestant. The Executive Director respectfully suggests that the Commission adopt the ALJ's PFD and issue the draft permit as drafted. Thank you, and we're available for any questions.
Thank you. I have none. Commissioner Gonzalez, any questions? All right. OPIC, good morning.
Good morning. Chairman, Commissioners, General Counsel, and Executive Directors, Attorneys, and Staff. For the record, I'm Jennifer Jamison on behalf of OPIC. OPIC agrees with issuance of this major amendment to the permit as outlined by the ALJ's proposal for decision. Specifically, OPIC agrees with the ALJ's finding that no evidence was presented to rebut the prima facie demonstration that the draft permit is adequately protective of water quality, contains sufficient provisions to prevent nuisance odors, and that the facility is adequately protected from inundation. Accordingly, the uncontroverted evidence shows that the permit is sufficiently protective of water quality and uses of the receiving waters under all applicable rules and regulations, and therefore OPIC must respectfully recommend issuance of the requested major amendment to this permit. Thank you. I'm available for questions.
Thank you. I have none. Any questions? All right. Well, I'm going to be presumptuous and just go ahead and offer a motion, and then we can discuss it on the other side if we need to. I agree with ED and OPIC. Commissioner Gonzalez, I move that we adopt the ALJ's proposed order granting summary disposition, that we issue the Executive Director's draft permit for a major amendment to Texas Pollutant Discharge Elimination System permit number WQ001-049-5030, and that we adopt the executive director's response to comments.
Second it.
All right, the motion has been made and seconded. All those in favor say aye.
Aye.
Aye, motion carries. Mr. Goodwin, thanks for trucking all the way out here. Ms. Smith, when you're ready, I'll ask you to please call the next item.
Item number 2 is the consideration of the ALJ's proposal for decision and proposed order concerning the application of ExxonMobil Corporation for amendment to air quality permit number 102982. The applicant will go first, followed by the protestants, the ED and OPIC. Because there are 2 parties, protesting parties, the applicant may have 10 minutes. Each protestant may have 5 minutes. The ED and OPIC will each have 5 minutes. The applicant may save time for rebuttal as it bears the burden of proof on the application. And we have Ms. Lisa Dyer here for the applicant.
Good morning.
Good morning, Chairman Neerman, Commissioner Gonzalez. My name is Lisa Dyer. My co-counsel Ian Davis and I are with the law firm of McGinnis Lockridge, and we're here today on behalf of the applicant, ExxonMobil Corporation. Key ExxonMobil representatives are here present and on the phone. We appreciate your review of the record in this matter. We also would like to thank the TCEQ Executive Directors, Air Permitting and Environmental Law Division folks, as well as the Chief Clerk's Office for their work related to processing this application and their review. This permitting project is straightforward. Despite the robust record, ExxonMobil seeks to amend its minor new source review permit to add 1 new furnace at its existing ethylene production unit at the Baytown Olefins plant. The executive director processed the amendment application consistent with similar permits, and the technical review is based on applicable rules, policy, guidance documents. The TCEQ is used for years. The protestants meaningfully participated in the contested case hearing, and the administrative law judge, Mitra Farhadi, thoroughly considered and weighed the issues presented by the parties. And after evaluating the evidence, the ALJ concluded that ExxonMobil had met its burden of proof, and that the application meets all applicable state and federal legal and technical requirements, including BACT, and a demonstration that the permit will be protective. And the evidentiary record is thorough. It provides a strong basis for the PFD and the proposed order recommended by the ALJ. The record also supports issuance of the draft permit without any changes as recommended by the executive director. Neither protestants nor OPIC filed any exceptions to the PFD or proposed order. The ALJ recommends that you adopt the executive director's 1-word clarifying change to the PFD, and we agree. We respectfully request that the commissioners adopt the executive director's response to comments, the ALJ's proposal for decision, and proposed order, and issue the draft permit. Thank you. I will reserve my remaining time for rebuttal.
Thank you, Ms. Dyer.
We have Mr. Levin for Protestant Environment Texas.
Good morning.
Good morning. My name's Teresa Blackwood. And so Mr. Levin allowed me to go before him.
Great.
So I got party status, and I'm very disappointed that my party status was challenged by Exxon. They didn't want to grant me a party status, but I lived there. I've lived there for a number of years, and I don't plan to move. All we wanted was a public meeting to understand what was happening, and that didn't happen. Monday night at 10 o'clock, 10:01 Monday night, I called Exxon because there's a chemical coming across. It filled the garage and a guest had left the door open. I called because the chemical was like in my throat and it wasn't in my eyes that time. But when I did that, I took a video. Since 2019, we have lived across the street from the BOP unit. It's called the 8-headed dragon. They want to do a 9th dragon. And when we found out about that and got an opportunity, we participated in this hearing. And the hearing was extremely enlightening. Things that we didn't even know to challenge about the chemicals that they put out and all of these things that could be hazardous. We just wanted information. So my husband and I have hours of video, hundreds of pictures. I have a log, 160 items on my log. The 160 items on my log are, hey, there's a smell, and we call Exxon. Hey, there's vibrations. Hey, there's issues. Hey, these are just notes. So some of it gets called in and some of it doesn't. But the 160 in 2023, there were 6 of them that were chemical incidents strong enough to call in to say, hey, what's happening? And this was at the BOP unit. And you're about to cut me off and I get it. But here's my point. None of them were reported to TCEQ. So TCEQ didn't get that information. So our comfort as citizens, this is my first meeting, so I don't know how this is supposed to be structured, but I was given this opportunity to be party status. It was brought up during the hearing and portion. There were a lot of things brought up in the hearing portion from other parties that challenged our safety and our health effects. And it's still being granted without those being addressed to where I can understand that. And so that's my issue, is that this approval process for them to get an approval for a permit that we just wanted information, when the information goes out, we still can't even understand it, and there needs to be a form for that. So those were my comments. Thank you.
Thank you, Ms. Blackwood.
And I would just note that much of this is not in the administrative record and can't be considered in the permit decision that's before you today.
And can I ask why it's not in the administrative record? Because I did make these comments during the hearing.
They were excluded on an evidentiary basis, is my understanding.
And so I don't know
What
how I didn't
it
get
goes
notice.
to the rules at the State Office of
Mhm.
Administrative Hearings and how they conduct their hearings, which are a quasi judicial forum. So it's like going to court. And so there are procedural rules
Mhm.
about evidence, and those judges make those rulings just like a judge would in a district court. And so it gets a little technical.
It does. It gets very technical. And with that said, would that have been noted in the hearing process to say that they would not be excluded, that they would be excluded?
There would have been a ruling at SOA.
Okay, I'll go back and look
Yeah.
for that ruling.
Yeah.
Okay, thank you.
Thank you, Ms. Blackwood. We appreciate your comments. And again, just to repeat, Ms. Smith's counsel, we can only consider, for this item that's before us this morning, we can only consider what's in the record. We understand that your experience and story expands beyond this particular record. And with respect to your concerns about the operation of the facility, I encourage you to continue contacting Exxon, but I would encourage you, if you think there's a violation or concern, to also contact our agency so our investigators have an opportunity to look into it as well. Thank you for being here this morning. Mr. Levine, good morning.
Good morning, Mr. Chairman, Commissioners, General Counsel, Elon Levine with the Environmental Integrity Project. As you know, Houston is in severe non-attainment for ozone and has been for decades. You also know that when an area is in severe non-attainment, that anytime a company, whether it's Exxon or somebody else, wants to build a major new source of air contaminants, they're required to do at least 2 things. One of the things that companies have to do in a non-attainment area before they build a big new olefins plant, ethane cracker, is to obtain offsets. And you know that that's a more than 1-for-1 offset requirement. So in the case of Houston, a company that's going to add new volatile organic compounds and nitrogen oxides, which is what's happening here, would be required to offset each new ton of pollution that they're putting into the air by more than a ton of pollution. And you all know why that is. It's to try to get the air quality back into compliance. It's a way that allows industrial growth while slowly reducing emissions into the air shed. So I know that you and your staff are familiar with this concept of offsets because it's required in Houston and has been for decades. The second thing that a company is required to do when they build a new facility in a non-attainment area is to meet the strictest pollution control technology standard. It's called lowest achievable emission rate, or LAIR. You all are familiar with that requirement in non-attainment areas. So how is it that ExxonMobil has built what the neighbors who live across the street, I found out, called the 8-headed monster or the 8-headed dragon? How were they able to build, starting in 2012, this entire Baytown Olefins plant? Not only the 8 units that are existing, but now this 9th ethane cracker that we're here talking about today, without ever having to demonstrate LAIR and without ever having to get a single ton of offsets. Oh, I'll tell you how. They gamed the system back in 2005. They got a permit, which is called the PAL permit, the Plant-Wide Applicability Limit Permit. And as you know, they've used that permit to build this entire facility, and now this 9th unit, never once having to offset a single ton of pollution and never having to demonstrate LAIR. We didn't file exceptions to this case because we know you've got the complete record, including our comments that we put in more than 2 years ago, and our closing brief, this is well briefed in our closing brief. So you've got all this, it's in the record. And the little nitpicky change that the exceptions is just we didn't care about, so we didn't need to respond on that. But I just want to make sure that you know we didn't file exceptions, not because not because it's not important, just because we have thoroughly briefed this. So how did Exxon build this entire new ethane cracker in Houston, in Baytown, in a severe non-attainment area, while maintaining that, again, federal applicability new source review does not apply? I'm quoting from their record, or as they say, it's exempt from federal NSR applicability. They got their PAL permit. They got that PAL permit in 2005. TCEQ did not have a PAL rule in 2005. There was nothing on the books in 2005. Zero, nothing. Your first PAL rule was promulgated in 2006. And as you know, you submitted that to the EPA for approval. EPA disapproved that.
That's time.
Can I
You
finish my sentence?
Just finish your thought, Mr. Levine. Thank you.
You resubmitted in 2000, EPA approved your PAL rule in 2012. I'm going to use Clean Air Act parlance here to cut it short. They have what Clean Air Act folks call an allowables-based PAL. Their caps are sky high. They've always been sky high. They're building this whole new plant, and they're going to build the 9th unit. They're gaming the system. And I just want you to know that when you bang the gavel and issue this permit, I want you to know that you are cheating. I'm sorry, but you will be cheating citizens of Houston and Baytown out of clean air.
Thank you, Mr. Levine.
Thank you.
We have the ED.
Good morning.
Good morning, Commissioners. General Counsel, Public Interest Counsel. My name is Contessa Gay with the Environmental Law Division, representing the Executive Director. With me and available to answer questions is Christopher Lochran of the Air Permits Division. Available online is Amanda Cranock with the Environmental Law Division and Margaret Eldridge and Chad Dumas with the Air Permits Division. This authorization, if issued, will authorize Exxon to implement a project that will increase production at the 2X unit at the ExxonMobil Chemical Baytown Olefins plant. For the reasons discussed in the Executive Director's response and exception to the ALJ's proposal for decision as filed, the Executive Director agrees with the ALJ's recommendation that the Commission issue the draft permit. The Executive Director did file an exception to the PFD seeking a clarification that the PFD have its intents changed. It was a minor clarification that the ALJ agreed with. The Executive Director maintains her position that the review of the application and draft permit meet all applicable statutory and regulatory requirements, and the Executive Director's staff performed the necessary review to ensure that the draft permit would meet all federal and state requirements and would be protective of the environment and human health and welfare. Thank you, and we are available to answer any questions.
Thank you, Ms. Gay. I have none. Commissioner Gonzalez. Thank you.
We have OPIC.
Good morning, Mr. Wayne.
Hey, good morning, Chairman, Commissioner, General Counsel, and the Executive Directors, attorneys, and staff. For the record, I'm Sheldon Wayne with the Office of Public Interest Counsel. In most respects, OPIC agrees with the administrative law judge, and her reasoning is laid out in the proposal for decision. However, because we found that the applicant did not carry its burden with regard to one specific issue, we respectfully recommend that the application be remanded to the ED for further technical review, specifically including a full NAAQS review for the 1-hour NO2 standard. Protestant Environment Texas raised a number of issues with this application, including problematic reliance on the existing PAL permit, failure to meet BACT requirements, and failure to demonstrate that emissions will not cause or contribute to air quality problems. Of these, OPIC found that Exxon met its burden of proof on all contested items, except for one specific issue related to air quality. With respect to the 1-hour nitrogen dioxide national ambient air quality standard, OPIC respectfully disagrees that conducting only a minor review and not a full NAAQS review was proper. Harris County is currently classified as severe non-attainment for ozone, of which nitrogen oxides are a key precursor. As such, we considered it of paramount importance that Exxon demonstrate compliance with applicable nitrogen dioxide national ambient air quality standards. Here, after considering the evidence, we found that it was more likely than not that under some operating conditions, permitted NO2 emissions could exceed the significant impact level, which is also referred to as the de minimis level, for the 1-hour NO2 NAAQS. As such, a full NAAQS review for the 1-hour NO2 standard should have been conducted to ensure that emissions remain at levels that are protective and in compliance with the applicable NAAQS. When calculating its NOx emissions, of which NO2 is a subset, Exxon relied on EPA's intermittent source guidance, which allows ratioing of emissions that are expected to occur infrequently or intermittently. Applying this guidance, Exxon calculated an emissions rate of 0.44 pounds per hour for NOx emissions associated with maintenance, startup, and shutdown operations associated with the selective catalytic reduction system. To arrive at the 0.44 number, Exxon took the actual NOx emissions allowed, which are 38.61 pounds per hour, and then multiplied it by the 99.6 hours allowed for the SCR MSS, the maintenance, startup, and shutdown of the SCR system. Then divided by 8,760 hours, which represents the number of hours in a year. This results in emissions from furnace XXI with ambient air concentrations of 7.3 micrograms per cubic meter, which is barely below the significant impact level of 7.5 micrograms per cubic meter. And this is before taking into consideration the existing 8 furnaces emissions and other background emissions, neither of which were included in the current application's modeling demonstration. We recognize that the Executive Director approved of this application's use of the EPA's intermittent source policy. However, it is OPIC's position that annualizing emissions that are allowed to occur for only 100 hours during a year during SCR MSS results in the model under-predicting the maximum ground level concentration that may, in reality, be permitted to occur during any one of those 100 hours. We are not convinced that annualizing emissions in such a fashion adequately demonstrates that the significant impact level for 1 hour NO2 NAAQS will not be exceeded during some maintenance, startup, and shutdown operations. Given this evidence, OPIC does not believe that Exxon has met its burden of showing that the operation of furnace XXI will not exceed the 1 hour NO2 significant impact level under some operating conditions. Therefore, OPIC respectfully recommends remanding this matter to the executive director so that a full NAAQS review for the 1 hour NO2 standard may be performed. Thank you, and I'm available for questions.
Thank you, Mr. Wayne. I have none. Commissioner Gonzalez, any questions? All right, Ms. Dyer, you've got an opportunity for a rebuttal. I think we have 7 minutes and 38 seconds left for you.
Thank you. I would just like to respond to some of the comments that you heard from the other parties. For Ms. Blackwood, I think it was clear on the record that we did not challenge her participation in the hearing. So she was admitted as a party at the preliminary hearing. And as to Mr. Levine's comments about gaming the system and cheating, I think we would have a strenuous objection to that characterization. The PAL permit was obtained legally and has been challenged many times before this proceeding and rejected by the State Office of Administrative Hearings in a prior hearing for the original permit 102982, as well as by the TCEQ itself in 2014. The PAL permit is a voluntary regulatory option for permit applicants who agree to meet all of the requirements associated with those permits, which includes keeping actual emissions below PAL limits that are site-wide limits. The PAL permit is not the most intuitive concept for many folks, but new source review permits are based on permit allowables, whereas a PAL permit is based on permit actuals. And so the combination of the two is a rather stringent set of requirements to be able to move forward operating a plant. But that's a path that Exxon has elected to take. But the important component of PAL, the legal component, is that it serves as a federal applicability level. And so that is the federal applicability review. It is baked into the permitting permits that they have. And all of those were obtained through approved and legal methods. With respect to the 1 hour NO2 standard, that issue is very well briefed in the record. And I don't know that we need to repeat all of it here. But I think the bottom line is that the 1 hour NO2 emissions and the maximum ground level concentrations of NO2 for the NAAQS review in the modeling were below the significant impacts level established by EPA and followed by TCEQ and expected of permit applicants everywhere. And neither OPIC nor the protestants offered any evidence to rebut that modeling demonstration. There were cross-examination questions, but there were no expert witnesses that offered a contradictory opinion for the ALJ to consider or for you to consider based on this record. So we would ask that you issue the draft permit as drafted, and thank you for your attention.
Thank you, Ms. Dyer. Any questions or comments? All right. Well, Commissioner Gonzalez, I don't see a reason to disturb the ALJ's work here, so I'm ready to move forward.
I don't either, so I move that we adopt the ALJ's proposed order, grant the permit application of ExxonMobil Corporation to amend permit number 102982, and adopt the ED's response to comments.
I second the motion. The motion has been made and seconded. All those in favor say.
A clarification, you said grant, and that would include in your mind issuing the permit, correct?
I couldn't hear you.
Grant and issue.
And issue the
Yes.
permit, yes. Okay.
Okay, we'll consider that a friendly amendment that I would second. And let me go ahead and call the vote. All in favor, say aye.
Aye.
Aye. Motion carries. Thank you, Ms. Smith. When you're ready, please call the next item.
Item number 3 is the consideration of the proposal for decision and proposed order concerning the executive director's denial of the application by William Bowling for a landscape irrigation technician license. The parties have been notified that the applicant, the ED, and OPIC will each have 5 minutes of oral argument time. The applicant should speak first and may reserve a portion of his time for rebuttal as he bears the burden of proof. And with that, we'll have the applicant, Mr. William Bowling, first. And I believe he may be virtual.
Mr. Bowling, are you there?
Yes, sir.
Okay, we hear you loud and
Okay.
clear. So go
All
ahead
right,
and
well-
introduce yourself and go ahead when you're ready, sir.
Well, I was planning on speaking, but it wouldn't give me the opportunity to speak because I didn't have an access code. But I was just going to text in some things and go from there. My name is William Bowling. I want to go over a few things that I've kind of had planned out here. I know a lot of you have probably read over all the information from the hearing and so forth, but I want to skip straight into it. So once I was sentenced into TDCJ, which is a prison, I was given the opportunity to teach, preach, and even become an inmate pastor. But I want to skip forward through everything from my past and so forth. And after prison, once receiving parole, I attended roughly 5 classes a week. Within 2 months, I was given an opportunity to take a job with Ashley's Furniture and get into the operations division. I roughly had about 120 people under me working for me while at Ashley's as an operations manager. Let's see here. When I first got out in 2018, I was living with some childhood friends, the Neil and Sheila Shirato, which is, I'll further get into that. He is the owner or part owner now that I am part owner, as well as Outdoor Creations. Neil had contacted me, the owner of the previous Outdoor Creations owner. He said he was looking to retire. He's 78 years old and had given me the opportunity to be part owner. With this being said, I needed to further my education within the landscape and irrigation field, so I needed to get my license. While working in Outdoor Creations, there was a lot of things that I did while that I guess from prison after gave me the opportunity to volunteer inside the prisons to kind of give back. So on Thursday nights, I go into Hutchins Unit Faith-Based Dorm, also go into Beto on Saturdays, which is a Kairos program that I give the opportunity to give back what was given to me. And it's something that I believe God has called me into doing. I want to step back a little bit as well. I got married in February of 2020. I have a stepson that has now graduated high school and he's in college. I have a stepdaughter, which is starting high school this year. And all these opportunities after getting out of prison, even though my past record kind of got in the way of quite a few things, I didn't let it bring me down. I didn't allow it to make any decisions on my career field or anything that I was doing and so forth. So let's see here. In 2022, I started these classes to get this license, and of course I was denied. With that letter being denied, I followed all the recommendations of sending in letters, roughly I think it was 4 letters, I may have to be corrected, and I'm sure Alicia will bring that up, but it's either 3 or 4 letters that were sent in via snail mail and email. And this is what I was told to do to make sure that it was received by TCEQ and everybody that would see this and so forth. And with that being said, about 6 months later, I reached out to somebody in the TCEQ division, and I received a call back a few weeks after that from Alicia Ramirez. She actually contacted me, so I didn't know who she was and so forth. I thought she was actually for me. And of course, later on, we'll find out that she was working for TCEQ. She wasn't working for me. So she was one that was trying to either help grant or to deny me of the letter, kind of. With that being said, I don't have too much more to say, but I know that about 8 months later, I received a call, or I noticed that a lady named Jennifer Jameson, which she, I guess, doesn't help, but she wants to make sure that the people that are filing for these are getting kind of a fair hearing, fair trial, to say. And I've spoken to her quite a few times, trying to make sure that all the information that I've sent in was received. Well, during the hearing, Alicia Ramirez had mentioned that she did not receive letters from me, but then I think they came back in a next hearing and said they received 1 letter. Well, all letters were sent at the same time via email and via snail mail, so I don't know how they received just one letter opposed to the rest that were inside that inside that package that was sent to them. Really,
Time.
Okay. Really,
Yeah, Mr. Bowling, if
thank
you just want to complete your thought.
Yeah, I just want the opportunity to further my career in the landscape and irrigation field, and I hope that you will agree with what the judge decision was made during the hearing.
All right. Thank you, sir.
Thank you.
Then we have the ED.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, Public Interest Counsel. My name is Alicia Ramirez, and I'm with the Environmental Law Division. With me is Rebecca Morgan of the Occupational Licensing and Registration Division. We represent the Executive Director in this matter. The evidence in this case showed that one morning in 2009, William Bowling, the respondent, went to his wife's residence. They were living separately at the time. He held her at gunpoint and he forced her to have sexual intercourse with him. Mr. Bowling was subsequently charged and convicted of aggravated kidnapping, which is a first-degree felony, aggravated sexual assault, another first-degree felony, and aggravated assault with a deadly weapon, a second-degree felony. He is now on the Texas Public Sex Offender Registry and must register annually for life. In January 2022, Mr. Bowling applied for a landscape irrigation technician license. The landscape irrigation technician license is a high-risk license that would allow Mr. Bowling, now a 3-time convicted felon, access to private residences, the general public, and businesses and their owners and employees, which could present opportunities to engage in sexually violent offenses. The landscape irrigation technician license would also allow Mr. Bowling access to persons at private residences or businesses in situations that could have a potential for confrontational behavior related to crimes against persons. The administrative law judge in this case concluded that the respondent met his burden of proof on the application and that he is fit to obtain the landscape irrigation license for which he applied. This conclusion was based only on the respondent's own testimony and 4 letters of recommendation from people who have no professional expertise to speak on respondent's actual rehabilitation. In fact, 2 of the letters were from a college friend of the respondent and that friend's father. And the 3rd letter was from a business owner who, according to respondent's testimony, is trying to help respondent obtain the license in the hopes that he might sell respondent his business or go into business with him in some way. Again, after helping him to obtain the license. The ED believes that considering the serious nature of respondent's crimes, this evidence is not sufficient to meet respondent's burden of proof to show that he is sufficiently rehabilitated and fit to obtain the high-risk landscape irrigation technician license that would allow him very close contact with the public. The EG objects to the administrative law judge's proposal for decision, findings of fact, conclusions of law, and proposed order. Specifically, the ED objects to findings of fact numbers 23, 38, 39, and 40. There was absolutely no evidence presented at the hearing to show that respondent would be unlikely to repeat his crimes with members of the general public, or that the context of his crimes related in any way to their likelihood to be repeated while in the performance of the duties of a landscape irrigation technician as stated in finding of fact number 23. There was no documentary or testamentary evidence presented at hearing on this issue. Similarly, the ED objects to findings of fact number 38 for the same reason. There was no evidence produced at hearing regarding what the low-risk designation given by the Texas Department of Criminal Justice means, or the level of risk that someone with a low-risk designation might pose to the community, or how likely such a person would be to reoffend. There was no documentary or testamentary evidence presented at hearing on this issue. The ED objects to finding of fact number 39 for the same reason, that no evidence was produced at hearing to support it. No evidence was produced to show how likely respondent would be to reoffend, or that the context of his past crimes would have any bearing on how likely he would be to repeat such offenses in the future, or how likely he would be to commit them while in the performance of duties as a landscape irrigation technician. There was no documentary or testamentary evidence produced at hearing on this issue. Finally, the ED execs to finding of fact 40. Considering all of the foregoing, respondent has not shown that he is fit to be licensed as a landscape irrigation technician. The ED also objects to conclusion of law number 11, which attempts to place some burden on the ED when our rules at 30 Texas Administrative Code sections 80.17A and 80.117B clearly state that the burden of proof is on the moving party and that the applicant has the burden of proof on his application. Based on these objections, the ED recommends that the commission rejects the administrative law judge's proposal for decision and issue its own decision that is consistent with the foregoing arguments. We are available for any questions.
Thank you, Ms. Ramirez. I have none. Seeing none from the dais. Ms. Jameson, good morning.
Good morning, Chairman, Commissioners, General Counsel, and Executive Directors, attorneys, and staff. For the record, I'm Jennifer Jameson on behalf of OPIC. OPIC has reviewed all evidence in this matter and firmly maintains the position advanced in its closing argument in favor of issuance of this license to Mr. Bowling. Accordingly, OPIC aligns with the entirety of the recommendation made by the ALJ's proposal for decision, as well as the substantive points made within the ALJ's exceptions letter. For clarity, OPIC would like to divide its focus into two brief sections, procedural and substantive. As stated in our closing argument, OPIC's concerns regarding the procedural issues in this case are rooted in its statutory obligation to advocate for the public interest, including principles like fairness in the contested case hearing process and adherence to applicable procedural rules and statutory authority. Here, there is substantial evidence indicating that Mr. Bowling likely sent his mitigating evidence not once, but twice, once via USPS and once via email to the ED in April of 2023, well in advance of the hearing on the merits. After initially testifying that Mr. Bowling had offered no mitigating evidence, the ED staff acknowledged that a single recommendation letter was submitted. Importantly, this letter contains high praise from Mr. Bowling's employer. After the hearing, it became evident that Mr. Bowling had likely submitted significant mitigation evidence, and it appeared that evidence was never reviewed by the Executive Review Committee. Accordingly, OPIC asserts that denial of his license without weighing such evidence would run afoul of Texas Occupational Code 53.023A, which lists the type of mitigating evidence that the ED must consider prior to denying a license. OPIC shares the ALJ's concerns in this case about elevation of form over substance, and we respectfully recommend the Commission conclude that the facts weigh in favor of Mr. Bowling. With respects to the substantive issues, OPIC would first direct the Commission's attention to TOC 53.003, which prescribes the legislative intent behind all provisions relevant to this case. The statute states in relevant part, "It is the intent of the legislature to enhance opportunities for a person to obtain gainful employment after the person has been convicted of an offense and discharged of the offense, and that this chapter shall be liberally construed to carry out the intent of the legislature." No one, including Mr. Bowling, denies the serious nature of Mr. Bowling's crime. Still, had our legislators intended for Mr. Bowling's crime to create a categorical bar to his licensure, they surely could have incorporated that language into statute, but that is not the case. Mr. Bowling's crimes were committed during a single and isolated episode in 2009, and one for which he has expressed regret in both court testimony and via written statement, acknowledging the wrongful nature of his conduct and the lack of any justification. There is no record of any other criminal wrongdoing during Mr. Bowling's life for which the ED seeks to deny his license. OPIC agrees with the ALJ's analysis and conclusion that the lone material criminal episode occurred in a context far removed and quite distinct from the workday world of a licensed irrigation technician, and Mr. Bowling's low-risk sex offender status indicates that he poses a very low danger to the community. In addition, OPIC would point to the overwhelmingly supportive recommendation letters sent on behalf of Mr. Bowling, including those from his friends and employers, in addition to evidence demonstrating that since his release from prison, he has consistently volunteered with Cairo's prison ministry at the TDCJ Beto unit. Mr. Bowling also obtained a degree in religious studies while incarcerated and successfully discharged from parole after completing extensive classes and counseling requirements. He has maintained steady employment and has since remarried and now has 2 stepchildren. In sum, while Mr. Bowling has committed crimes that on paper would present grounds for the commission to deny his application, the remote nexus between the specific circumstances of his offenses and the duties and responsibilities of an irrigation technician, his intervening transformation for the better, and the other countervailing considerations under Section 53.023 and Chapter 53's broader policies ultimately weigh in favor of granting his license and application here. OPIC asserts that denying Mr. Bowling's application on the record would be contrary to the legislature's manifest intent in Texas Occupation Code, Chapter 53. Thank you. I'm available for questions.
Thank you, Ms. James. I have none. Commissioner Gonzalez? Saying none? Okay.
And, normally we would allow an applicant rebuttal, but Mr. Bowling used all of his time during his original presentation.
Right. Thank you. Commissioner Gonzalez, I'm generally aligned with the ALJ's proposal here. And the one exception to that is with respect to the burden of proof on the convictions. And I'm referring to conclusions of law 11 as well as 16. And it's the applicant's burden to prove their fitness for licensing. And in any event, the convictions, I don't think were ever in dispute. Other than clearing up our statement of law and those conclusions of law, I would go ahead and allow for the issuance of this license. And I'm prepared to offer a motion to that effect as well.
I'm in agreement.
Okay, let me go ahead and make that motion then. Commissioner Gonzalez, I move that we adopt the administrative law judge's proposed order. However, because Mr. Bowling has the burden to show that he is currently fit to hold a landscape irrigation technician license, and in order to be consistent with past licensing decisions, the commission amends conclusions of law numbers 11 and 16 to state 11. Mr. Bowling has the burden of proving that he is fit for licensure despite his criminal convictions, with the following citations: Texas Occupational Code, Section 53.0211B, 30 Texas Administrative Code, Sections 80.17A and 80.117A and B. And conclusion of law 16, Mr. Bowling was convicted of one or more offenses described by Texas Occupations Code, Section 53.021A, proving all 3 categories of offenses described there. And that statement is followed by the following citations: Texas Occupational Code, Section 53.021A, and Accord 30 Texas Administrative Code, Section 30.33H1. Excuse me. That's the end of my motion.
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 4 is the consideration of the petition filed by Circle S Midlothian LLC for the creation of Circle S Middle Municipal Utility District of Ellis County. The parties have been notified that the commissioners will not take oral argument, but may ask questions. And those who have been signed will be noted for the record.
Thank you, Ms. Smith. Commissioner Gonzalez, I feel like we've seen a lot of these recently that really look nearly identical. I think Ellis County here has clearly demonstrated that they're an affected person. I would grant the request, and I would also include an ADR referral.
I agree.
All right. That was not actually a motion, but I can probably make one.
I can make one.
Go ahead.
I move that we grant the hearing request of Ellis County, refer the matter to SOA for a contested case hearing on the petition, and refer this matter to the Commission's Alternative Dispute Resolution Program concurrently with the SOA preliminary hearing scheduling process.
I second that motion, and I'll call the vote. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, please call the next item.
Item number 5 is Love's Travel Stops and Country Stores Incorporated. Request for consideration regarding an application for a major amendment with renewal of TIPD's permit number WQ0015618001. The parties have been notified that the commission will take oral argument, or will not take oral argument, but may ask questions, and those signed in will be noted for the record.
Commissioner, it's clear to me that this draft permit does not comply with our rules, so I'm going to go ahead and move that we grant the request for reconsideration by Murphy DeShong, and that we remand the matter to the executive director for further evaluation.
A second.
Motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 6 is the consideration of a resolution appointing 7 nominees to the Water Utility Operator Licensing Advisory Committee. And the executive director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and the Public Interest Council. I am Rebecca Morgan, Special Assistant to the Deputy Director of the Occupational Licensing and Registration Division on behalf of the Executive Director. With me is Alicia Ramirez with the Environmental Law Division. We are here today to request the Commission's consideration and approval to appoint a total of 7 individuals to the Water Utility Operator Licensing Advisory Committee, known as WULAC. These recommended appointments will replace advisory committee members whose terms expire on August 31st, 2024. 2 of the nominees are reappointments, Larry Bell and David Garza. The other 5 nominees are new appointments and include Adam Farguson, Zachary Lilly, Eduardo Montagna, Wesley Nebgen, and Leanne Wilson. If approved, their terms will run from September 1st, 2024 through August 31st, 2028. WULAC consists of 13 members who represent various water and wastewater regulated entities from diverse geographic areas of the state, ethnic groups, businesses, government entities, and associations. WULAC's sole duty is to advise the Commission regarding water and wastewater operator licensing and training issues, and to facilitate communication between the Commission and the water and wastewater utility industries. The WULAC has no executive or administrative powers or duties with respect to the operation of the Commission, and all such powers and duties rest solely with the Commission. A notice of request for nominations to fill these vacancies was published in the February 9th, 2024 issue of the Texas Register. An email solicitation was also sent to all individuals who hold a current TCEQ water license, and current members of WULAC were asked to recommend potential members. The Occupational Licensing and Registration Division received a total of 45 nominations. After a thorough review of all of the nominees and making a reasonable attempt to provide balanced representation, staff is recommending the appointment of 7 nominees to this advisory committee. The 7 recommended nominees would balance the representation across the state with current members with respect to geographic location, technical background, and affiliations with associations, government entities, or training providers. In conclusion, staff respectfully requests adoption of this resolution. Thank you. We are available for any questions.
Thank you, Ms. Morgan. I have none. Seeing none. Ms. Smith, has anybody signed in to speak on this item?
No one is signed in on this item.
Mr. Arthur, what says OPIC?
Good morning, Chairman and Commissioner. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC supports adoption of the resolution.
Thank you. Commissioner Gonzalez, I do too. I want to thank all of the nominees for their willingness to serve, and I'm ready to move forward with the resolution.
Yeah, I'd also like to thank them for their willingness to serve. That's grateful to have you. You want to make it or you?
Sure. Commissioner Gonzalez, I move that we adopt the executive director's proposed resolution appointing the following nominees with terms effective September 1, 2024 for a 4-year term to expire August 31, 2028. Larry Bell, David Garza, Adam Farguson, Zachary Lill, Eduardo Montaña, Wesley Nebgen, and Leanne Wilson.
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next items.
That brings us to our enforcement docket, which are items 7 through 54. And the executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Michael Parrish of the Enforcement Division, and with me today are Melissa Cordell, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 7 through 54. The total assessed administrative penalties are $1,159,559, with $212,701 deferred. $336,205 applied towards supplemental environmental projects, and $610,653 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Mr. Parrish. I do not have any at the moment. Commissioner Gonzalez, seeing none. Ms. Smith, is anybody signed in to speak?
Yes. On number 7, we have Michael Bates.
Not seeing a Michael Bates in the
Hi.
room.
Virtual.
Mr.
Yes.
Bates, are you online?
Virtual.
Can you hear me? Are you
Yes.
there?
Yes, sir. Are you able to hear me?
Loud and clear. Go ahead when you're ready, sir.
Are we limited to one party speaking, or will both myself and my co-counsel Wendy Hammond have 3 minutes?
The folks who have, let me have our general counsel answer this.
I believe in the past we've had one person per party, but it's at the commission's discretion.
We'll listen to both of you. Yeah. And it's you, Mr. Bates, and who is the other person?
My co-counsel Wendy Hammond, would she be able to speak first since she's currently present at the meeting?
Of course.
Thank you.
I see her smiling at me, Mr. Bates. So good morning, Ms. Hammond. Is the light on your microphone?
Now it's on. Can you hear?
Yeah, I think we've got you. Yeah, thank you. Good morning again.
Good morning. My name is Wendy Hammond. I am a staff attorney with the Legal Aid of Northwest Texas, here representing the Joppy Freeman Towns Association. You may recall this came before the commission before in the May 22nd, 2024 commission's agenda. And this is a follow-up because it was remanded. So what we are asking now is we hope that the commissioners would ask the staff if they have finally obtained and reviewed the Texas Star Ready Mix's operational logs, because the public would like to verify the applicant's claims. And the reason why it's important is because we need to make some clarifications. The last time there was an issue regarding the Public Information Act, that is still to the case. There are 2 things that we requested: confidential business information, and that went to the Attorney General's office, and that was decided. We also asked for operational logs. That was the agency's opinion is that it's not in the agency's possession. Therefore, the staff didn't even bring it to the Attorney General's office. So there's never been an opinion on that. The commissioners need to understand that the implications of the staff's current position is because a standard permit, a permit by rule, standard exemption, all of it requires the applicant to obtain and produce operational logs, and that TCEQ has a right of access. Therefore, the government code, section 552.002, the definition of public information, is that if it's maintained or required, produced by law, by a government body with a right of access to it, then it's a public document. These requirements are met, the TCEQ staff is refusing to provide the public these documents. If these documents are never reviewed by the agency in an investigation, in an enforcement, or even in the permit application that is a part of this agreed order, and the public doesn't get access to it, then when are these legally required documents ever reviewed for legal compliance? This undermines the protectiveness of the standard permit itself because nobody is checking to see if there's legal compliance is actually happening. It jeopardizes TCEQ's delegated authority under the Federal Clean Air Act and under the Texas State Implementation Plan. Right now, it is only a staff interpretation, but once a final decision by the commissioners occurs, it becomes a rule of general applicability because this has happened not only in this case, but in other facilities in Dallas, Fort Worth, and Lubbock area. And as that, this rule of general application would have occurred without following the Administrative Procedures Act's rulemaking requirements. Therefore, we request that you ask them whether or not they've obtained the documents, and if not, remand them to that they have to obtain the documents, and to clarify to agency staff that these documents are actually public information that the public should have a right of access to. Thank you.
Thank you, Ms. Hammond. Mr. Bates, you can go ahead when you're ready. Mr. Bates, we can't hear you. You might double check your mic.
Good morning. My name is Michael Bates. I'm a staff attorney with Legal Aid of Northwest Texas, representing Joppy Freedmen's Town Association. We are requesting the commissioners deny and remand this proposed agreed order because the facts and considerations we will present indicate that this agreed order is improper, inadequate, and inconsistent with the requirements of the statutes and rules within the commission's jurisdiction. TCEQ improperly assessed the penalty according to the requirements of Texas Water Code 7.053 and TCEQ's corresponding penalty policy document. First, TCEQ failed to assess a culpability penalty. According to TCEQ's penalty policy, in assessing culpability, personnel will determine whether or not the respondent could have reasonably anticipated and avoided each violation. Respondent knew they were operating without proper authorization since September 2022. Despite withdrawing a PBR permit and applying for a new permit, respondent knowingly operated without authorization for months. Additionally, respondent failed to disclose a month and a half of unauthorized operations, and this was only found at the recent commissioners meeting. Even the Office of Public Interest Counsel asked why culpability was not assessed. TCEQ cannot assess a 20% deferral of the penalty when respondent was considered culpable, and cannot assess a 10% decrease for being a high performer. Second, TCEQ failed to assess the economic benefit gained by operating without proper authorization, which according to the penalty policy must be based on respondent avoiding or delaying maintenance or operating cost, receiving increased revenue during non-compliance, and avoiding or delaying capital outlay for any item required by the permit. TCEQ fails to penalize respondent for the numerous other avoided costs for complying with a standard concrete batch plant permit. This would at least include the high cost of paving the entry and exit ways with concrete, building mandatory compliant fencing, building stockpile walls, and making the batch plant itself compliant. Proof of this is in the JFTA written comments. Third, TCEQ failed to accurately assess a penalty regarding the extent and duration of the prohibited operations. TCEQ seemed to estimate the number of monthly events and does not know the exact number of violations because they refuse to collect respondents' operating logs. They state at this stage of the enforcement process, operational records are not necessary. Should this matter go to litigation, TCEQ would obtain necessary records through that process. On the contrary, these records are crucial for finding the extent and duration of the prohibited operations. For example, by failing to collect these records, the agency did not know that respondent had operated for nearly 2 additional months without authorization and failed to assess a penalty for the daily operations respondent admitted to at a TCEQ meeting. If respondent failed to keep the operational logs, this additional non-compliance must be assessed against them. Fourth, TCEQ fails to deter future violations by deferring the entire $5,000 fine for a month and a half of previously undisclosed illegal operations. Finally, JFTA requests a supplemental environmental project in this case. Thank you.
Thank you, Mr. Bates. Let's stay with this item for a moment. I understand that there's counsel for the respondent available for questions. Mr. Birch, are you with us?
Yes, good morning, Commissioners. Can you hear me?
We can. I just wanted to give you an opportunity to respond to the argument that you've heard.
Sure. First off, good morning, Commissioners and Ms. Smith. I'm sorry I can't be there with you in person this morning. The respondent in this case has, I don't understand the somewhat of a vendetta that has been alleged against with this company by Lone Star, by Legal Aid of Northwest Texas. I've been involved in many enforcement actions over my 25 years, and I don't think I've ever seen such attention paid to a facility. The concrete batch plant involved here is nothing unusual. It's been operating in compliance for years before there was a discovery that apparently the permit had been voided years before the current respondent ever owned the facility. So this was a surprise to everyone. The respondent has been totally responsive to TCEQ. It has worked with the enforcement division. There were real questions back in that early time period about whether about the status of its permit. So I know that Legal Aid of Northwest Texas categorized this as a blatant continuing to operate after its permit expired, but I've seen some of the records and there were real questions about that. So it's a fact issue about whether they were even told or whether there was the ED even thought at the time that the permit had expired and been voided actually by TCEQ. So what I ask you here is the respondent has paid an enormous cost in this matter. It actually had absolutely no culpability in what happened. All of the events that resulted in this permit being voided occurred before it ever even purchased the facility and began operation. So they've paid an enormous penalty. I urge you at this point, the TCEQ's enforcement staff has thoroughly reviewed this several times now and ask you to adopt the proposed agreed order.
Thank you, Mr. Birch. I want to give Executive Director staff an opportunity to respond to anything that you've heard.
Thank you, Commissioner or Chairman. My name is
Sure,
Melissa Cordell.
microphone.
Ooh,
Maybe so.
hi, I'm Melissa Cordell. Okay, so several points that were raised earlier I'd like to address. In regards to operational documents from the facility, they've continued to not operate since August of 2023. Yes, August 9th, 2023. We have fulfilled the terms of the public information request. I'm not aware of another public information request in which there's been any ask for any additional documentation. So we have provided what it is that we have. In terms of culpability, we did review again whether or not this would meet with the criteria that we have within our division on assessing culpability. This does not rise to that level. We did not apply it in this case, and that is consistent with the other cases that we handle that are very similar. In terms, there was a mention of giving them a reduction due to high performer. I do not see that in this order. They are not a high performer, so they did not get a 10% reduction there. We did, based on discussion at the May 22nd, 2024 commission agenda, there was an indication about operating earlier than what was previously in the order. We did back up that date and assessed additional monthly events and which did result in the penalty increasing. We also did do that financial inability to pay review again, and that came out with the same result as before. And so that amount, that payable amount did not change. And as into the comment about being a deterrent, as they've continued to, Texas Star has continued to not operate, this order has had the effect of being a deterrent. They are not in operation.
Thank you, Ms. Cordell. And we're confident that are not operating, have not operated since August 9th of last year.
Correct.
Okay, appreciate that. Ms. Smith, is there anybody else who has signed in to speak?
No, we have numerous people signed in and available to answer questions on items 9, 10, 11, 13, 14 through 17, 19, 23, and 32. And so they've all indicated that they're simply available for questions, and we'll note that they're signed in for the record.
Okay, thank you. Mr. Arthur, I'd like to give you an opportunity to speak to this item 7 specifically, if you have any thoughts on it, and as well as to the entirety of the docket.
Thank you, Chairman. As expressed in May, we did have concerns regarding the Texas Star ready mix item, and we thought remand at that time was appropriate. Since that time, we've reviewed the backup documentation this time around, including the financial inability to pay documentation, and we're satisfied at this point on that particular item. So with that being said, we support adoption of these enforcement orders as presented by ED staff.
Thank you, Mr. Arthur. Commissioner Gonzalez, I think I come down in the same place. For me, the financial inability to pay aspect of this item 7 analysis, it gives me some pause about the state of an operator, but I think, and their ability to actually meet the requirements of operating. But I think that's really a question for future permitting and not for the enforcement action in front of us. So that's a long way of saying that I'm ready to move forward with this enforcement docket.
I agree. And, we asked the staff to go back and look at that and remanded that, and they did that and came back with still the financial inability to pay. So I move that we adopt items 7 through 54 as recommended today by the executive director.
I'll second that motion and call the vote. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call the next item. Tell you what, we're going to take a 5-minute recess. I've got 10:42. We'll come back at 10:47. We are in recess. right, we are back after let's do this. We're back after a short break. Time is 10:47 a.m. Ms. Smith, please call the next item.
Item 55 is the consideration of the petition for rulemaking filed by Harris County requesting that the commission adopt rules in 30 Texas Administrative Code, Chapter 116, Subchapter F, Standard Permits. The petitioner is the moving party and should present the matter, followed by the ED, OPIC, and any interested persons. OGC recommends providing 5 minutes each to the petitioner, the ED, and OPIC, and recommends 3 minutes each for other interested individuals who are signed in. Presently, we have 1 person signed in. So we would begin with the petitioner, and I believe we have Mr. Ryan Cooper from Harris County Attorney's Office here.
Mr. Cooper, are you with
online.
us virtually or in the flesh? Mr. Cooper, if you're trying to join us virtually, we can't hear you. You might check your mute button. Mr. Cooper? All right, why don't we come back to Mr. Cooper and hear next from the Executive Director staff. Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Michael Wilhoit with the Air Permits Division. With me is Amy Browning of the Environmental Law Division. Also available for questions is Sam Short, Deputy Director of the Air Permits Division. Before you today for your consideration is a petition for rulemaking requesting revisions to Chapter 116, Control of Air Pollution by Permits for new construction or modification, Subchapter F, Standard Permits. The petition requests revisions to Chapter 116 to require the Commission to conduct updated protectiveness reviews for air quality standard permits when the United States Environmental Protection Agency, or EPA, adopts a new National Ambient Air Quality Standard, or NAAQS, and revise the appropriate standard permits to address the findings of the updated protectiveness reviews. The Executive Director respectfully recommends denial of the petition. Standard permits are a streamlined mechanism to authorize minor sources for specific, well-characterized classes of facilities and are an EPA-approved element of the Texas State Implementation Plan. In accordance with existing agency rules, Executive Director staff already evaluate the protectiveness of air quality standard permits on an ongoing basis as new or revised air quality standards go into effect. When deciding whether to amend a standard permit, the Commission must consider whether a condition of air pollution exists, the applicability of other state or federal standards, and whether the standard permit utilizes best available control technology. As a recent example, staff have already begun the review of certain standard permits due to changes to the NAAQS for particulate matter recently promulgated by EPA. These evaluations require significant amounts of time and agency resources. The rule language suggested by the petitioner is overly prescriptive and would not allow the Commission sufficient flexibility to prioritize these reviews appropriately. Thank you for your consideration. We're available to answer any questions you may have.
Thank you, Mr. Wilhoy. I do have a few questions. You referenced resource demands. Can you talk a little bit about what it takes to conduct a protectiveness review and what it takes to update a standard permit?
Mr. Chairman, to respond to that, I'm going to yield the microphone to the Air Permits Division Deputy Director, Sam Short.
Thank you. Good morning, Mr. Short.
Good morning, Chairman, Commissioner. Can y'all hear me okay?
Yeah.
So to conduct a protectiveness review is actually a pretty extensive operation. In air permits, we call it air dispersion modeling, not a protectiveness review, but protectiveness review is the general term. The first thing we have to do is we actually have to gather all the data of the sources, emission calculations, stack information that goes into the air dispersion model. It takes several staff quite a bit of time to research that information, to do the calculations, and they could spend quite a bit of time working on that. That's just to get the model started. And then once we do the modeling exercise, that takes a significant amount of time to conduct. All in all, the first stage of the process, just to get the first look, can take over up to and over 6 months, just to get the first look at the protectiveness review to see what the current standard permit would look like. Then we have to determine if any changes are made. If changes are required by the standard permit protectiveness review, it's not as easy as just putting those into the permit. We actually have to make those changes, redo the emission calculations, redo the model, and determine if those changes made a significant difference in that protectiveness review. And rinse and repeat basically several times until we get to a point where we have determined what exact changes are needed. That's all prior to us entering in the public notice, the stage of proposing the permit, and then we go to the public notice and public participation process, the rulemaking process, all before we can present that in front of y'all for adoption. So time-wise, it can take a significant amount of time and staff resources, 2 to 3 people just from the Air Permits Division to work on this project and take them away from the other work that they're doing for the division.
All right, thank you. I appreciate that. Do you recall, at some point recently, we revised the concrete batch plant standard permit. Do you recall how much time it took us to do that particular project?
I believe that project, we actually started internal looking around the end of 2021. I can't speak exactly, but I know the actual process took us about 2 years to go through that process. So we didn't actually get to adoption until I believe 2024. So it takes quite a bit of time and effort to do this, and it takes staff resources, not just from our division once you enter a rulemaking process, but from other divisions across the agency as well.
And do we have any control over when this work lands on our desks? In other words, do we have any control over when or how often the EPA will revise the NACs?
We do not, Chairman, and we also and oftentimes don't know what the exact final NACs is going to be until final proposal. For example, the recent NACs, there was a range up until the time that they proposed it. So we had no ability to plan until a final NACs was proposed, and we didn't know the exact time when that was going to be proposed.
Ms. Browning, you look like you had something to say.
Yes, sorry, Amy Browning for Environmental Law Division. I believe you meant to say up until they adopted.
Adopted, sorry. Yes, you're correct, Amy. Sorry, it's adoption.
I'm going to credit myself with catching that if you hadn't. Yeah. So we didn't know. The point is we didn't know it left until it was.
That's correct,
it was
Chairman.
done. Yeah. And for the teams who do this work, the air dispersion modeling and actually updating the permit, what else is competing for their time? What other projects are they working on?
In addition to doing the actually having to do the work, the air dispersion modeling group audits all of our case-by-case permits, the modeling that comes in from those, whether it be a minor or a major source. They also work on any kind of other standardized authorization we may be currently working on or have in the works. The staff that do the rulemaking, they also assist in working on things like the state plans that we're having to do and some of that work. In addition to the actual permitting staff who have to make themselves available to do the calculations and to do the condition drafting and those things that are actually working on permits and also helping with the state plans that we have to do. So there's a lot of competing priorities that we have. And primarily it takes them away from the primary duty of reviewing permits as they come through.
Okay. Thank you, Mr. Short. I appreciate that. Ms. Browning, anything to add from the Environmental Law Division perspective?
No, Chairman, I don't have anything else. Thank you.
Thank you. Commissioner Gonzalez, any questions or comments?
I just want to clarify. So the group working on this, they would be working on air permits, complying with federal rules, and looking at new standards.
That's correct, Commissioner.
I mean, that's a lot.
Including SIP submittals. And
our group does not work on those, but we do work on state plans for like the recent promulgated new source performance standards.
Okay. All right. appreciate that. I think we have OPIC up next. Morning, Mr. Martinez.
Good morning, Chairman, Commissioners, General Counsel, and Executive Director. My name is Eli Martinez, and I'm with the Office of Public Interest Counsel for the record. We've reviewed this petition for rulemaking requiring an updated protectiveness review for air quality standard permits within a year of a published change in NACS and revision of the appropriate permits based upon the results of that updated protectiveness review. OPIC respectfully recommends that the petition be granted and the rulemaking proceedings be initiated. We appreciate the notion that when the Commission promulgates a standard permit, it must demonstrate that emissions from any facility operating under that standard permit will not cause or contribute to the exceedances of the NACS. Such an assurance requires timely analysis to determine whether updates to our standard permits are needed to comply with new science and changing environmental conditions based upon updated NACS or effect screening levels. However, we also do recognize that the one-year deadline proposed in this petition may not pose a feasible timeline in some instances or effectuate a proper and sensible prioritization of agency resources. Further, a new or changing NACS, which requires an updated protectiveness review, may not always necessitate that a standard permit be amended. For these reasons, while we support initiation of the rulemaking process in response to the petition, we would aim to ultimately analyze and craft a rule that both ensures that our standard permitting program timely complies with both the federal and Texas Clean Air Acts, while concurrently creating sensible timelines that duly consider finite agency resources. If the petition is granted, OPIC looks forward to actively participating in any rulemaking proceedings initiated in response to this petition. Thank you.
Thank you, Mr. Martinez. Commissioner, any questions for OPIC? Why don't we go back to the petitioner and see if Mr. Cooper has been able to join us. Mr. Cooper, are you there?
All right, can you hear me this time?
Yes, loud and clear. Go ahead when you're ready, sir.
Fantastic. I apologize, I was having a microphone issue. Good afternoon, Chairman Neerman, Commissioners. My name is Ryan Cooper, and I represent Harris County Attorney's Office. I appreciate the opportunity to speak with you this morning, and I'm here to speak on behalf of our petition for rulemaking, which would require within 1 year of an update in the NACS that the TCEQ perform an updated protectiveness review and, if necessary, update its standard permits. I'm here to address some concerns that the Executive Director has and to answer any questions that you might have. The standard permit program is a central part of Texas SIP, and the idea being that each entity that registers under the standard permit will not contribute in any way to an exceedance of the NACS. And so naturally, when the NACS change, we would expect that an updated protectiveness review would be performed so that the permits reflect the most recent science. And this is not something that we think the TCEQ disagrees with us on. Because on multiple occasions, TCEQ, as in response to comments and community meetings, has said that when the NACS change, they will perform an updated protectiveness review. Now, the impetus behind Harris County bringing this petition for rulemaking is we're concerned that this might not be occurring. Now, we've done Public Information Act requests, and we've gotten some information from those requests that, certain standard permits haven't had a protectiveness review performed in a long period of time. It seems, for example, the permanent hot asphalt mix standard permit, based off what we received, and we may not have received everything, but based off everything we received, that protectiveness review hasn't been performed since 2003. Now, if that's the case, there's been a change to the NO2 NACS, the SO2 NACS, and the PM10 NACS at least once. There's been 2 changes to the ozone NACS, and now 3 changes to the PM2.5 NACS. And so what we're seeing is, a protectiveness review that's outdated and no longer is catered towards achieving the NACS. And I'm not just picking on the hot asphalt mix standard permit. There's others. It seems that the concrete batch plant with enhanced controls permit hasn't been updated since 2004. Boilers haven't been updated since 2006. Electric generating units, 2007. Permanent rock crushers, 2008, so on and so forth. Now, if we're incorrect, and as the Executive Director had mentioned in their response to the petition for rulemaking, and that protectiveness reviews are always going on in the background, and it's a draw on resources. then we would just like to know when those processes are going on. And if possible, would like to be involved in that. But, if it's the case that some protectiveness reviews have not been performed, say since 2002, in the case of the hot asphalt mix standard permit, then it's been about 22 years since it's been done. And I think we can all agree that that's too long a period of time. And if that's the case, this petition for rulemaking would be particularly relevant and would help to achieve the NACs and have accountability in government. And it would be very beneficial in that respect. And if the TCEQ is concerned that 1 year is too prescriptive, and that too much resources would have to be diverted to it, it can't be done within a year, then that's a conversation Harris County is willing to have. Certainly, it could be 2 years, and Harris County would engage in that process and would comment if that's a rule TCEQ would make. But I think we can all agree that 22 years is too long. With that, I yield the rest of my time for any questions that you may have. Thank you again for hearing me.
Thank you, Mr. Cooper. Any questions? All right, seeing none. I understand we have somebody signed in to speak.
Yes, we have Mrs. Autumn Hensick.
Will you say the name again?
Autumn Hensick.
Ms. Hensek, are you with us? Ms. Hensek? All right. Tell you what, I want to allow the executive director's office an opportunity to respond to anything that you heard, if you have anything you'd like to add or.
Thank you, Chairman. So standard permits are, as we mentioned before, a minor source, and they are for like-kind facilities. When we conduct a protectiveness review, it is highly conservative in nature, and more conservative than if someone were to come in for a case-by-case permit. For the timelines, the prescriptiveness of the timelines, the issue is a combination of the number of standard permits we have. We have 22 standard permits, and the fact that just one of those would take us around 2 years to do. So it's hard to predict exactly how long. So we have to prioritize the standard permits. We have to evaluate them, frequency of use, likelihood that the change in NACs will actually result in something. And so there's a lot of parameters we have to look at just to determine and prioritize the work on those standard permits. And even a 2 year timeline is overly prescriptive to do them all. That's 22 standard permits total. Our preliminary evaluations, we have certain standard permits that like ammonia storage that don't have particulate matter in them. So those can be eliminated because they wouldn't have those emissions. So our estimate's about 16.
Okay, so some NACs will implicate a greater percentage of those 22 standard permits than others.
That's correct, Chairman.
Yeah, okay, I got you. All right, appreciate that. Well, here's where I come down, Commissioner. We have a process for implementing a new or revised NACs. I think our staff, I think that process gives our staff appropriate flexibility. It allows them to prioritize risk and manage workload. I do believe that staff is managing the process in a reasonable manner, and so I'm inclined to deny the petition.
I agree. I understand the concerns raised by Harris County, and I appreciate the interest the county has shown in protecting our state's air quality. Our agency has a very important responsibility to implement the state and federal requirements for clean air, and we don't take that lightly. So, but I do agree with you, Chairman.
All right. Well, let me go ahead and offer a motion then. Commissioner Gonzalez, I move that we deny the petition for rulemaking concerning amendments to 30 Texas Administrative Code Section 116.605 for the reasons stated in the Executive Director's response memorandum. Further move that we issue the Executive Director's proposed order, but modify the order to include the following explanation. Quote, the Commission recognizes that the Executive Director already evaluates the protectiveness of air quality standard permits on an ongoing basis as new or revised air quality standards go into effect, and believes that the rule language suggested by the petitioner is overly prescriptive and would not allow the Commission sufficient flexibility to prioritize and conduct adequate protectiveness reviews, end quote, and end of my motion.
I second it.
Motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 56 is the consideration for publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 331 regarding underground injection control. And the Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Dan Hanna with the Underground Injection Control Permit Section. The Executive Director requests your approval for publication and hearing on proposed amendments to 30 TAC Sections 331.11 and 331.132 of the Underground Injection Control Rules. The proposed rulemaking implements Senate Bills 786 and 1186 from the 2023 Texas Legislature. The proposed rules would reflect the Railroad Commission's responsibility for the regulation of closed-loop geothermal injection wells and brine mining injection wells as established by the legislature. The Executive Director requests your approval of the publication and hearing on the proposed rules and permission to make non-substantive corrections if necessary to comply with Texas Register requirements. Thank you for your consideration. We are available to answer any questions.
Thank you. I have none. Commissioner Gonzalez, has anybody signed in to speak?
No one has signed in on this one.
Mr. Arthur, what does OPIC think?
OPIC has reviewed this rulemaking and understands that the proposal implements Senate Bills 786 and 1186, addressing agency jurisdiction over the regulation of closed-loop geothermal injection wells and brine mining injection wells. The proposed rules remove Commission requirements for the regulation of closed-loop geothermal injection wells and recognize the Railroad Commission as the regulatory agency responsible for closed-loop geothermal injection wells and Class 5 injection wells used for brine mining. OPIC agrees that the proposed rule changes will guide the public to the correct state agency for the regulation of these types of injection wells. We also recognize this rulemaking may result in a more streamlined and efficient permitting process for the regulated community. OPIC will attend the public hearing and review any public comments received. In conclusion, we support publication. Thank you.
Thank you. Commissioner Gonzalez, I'm certainly ready to put this out for public comment.
Okay, I move that we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 331, Underground Injection Control, as recommended by the Executive Director.
I second. Motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item number 57 is our public comment session. The Commission will receive comments from the public on any matters within the jurisdiction of the TCQ, except for pending permit matters, including those pending permits that might still be on appeal, or other contested cases such as enforcement items or specific enforcement concerns. These are subject to the ex parte prohibition found in Texas Government Code Section 2001-061. In the interest of time, speakers will be limited to 3 minutes each, with the total time for public comment limited to 1 hour. Like everybody did note that the commission's discussion of subjects for which public notice has not been given are limited to statements of specific factual response and recitation of existing policy. With that, I'll call the first person. We have Mr. Errol Summerlin, and I believe he is virtual.
Mr. Summerlin, are you there? Mr. Summerlin, we're not able to hear you. Are you with us? Wait, well, let's come back.
Ms. Cindy Valdez.
Ms. Valdez? Ms. Valdez? Come back.
I'm here.
Oh,
okay.
Wonderful. You're coming in loud and clear, Ms. Valdez. Thank you for joining us today. Why don't you go ahead and state your name again for the record, and then the floor is yours.
Thank you so much. My name is Cindy Valdez. Good afternoon, commissioners, and thank you for the time to speak today. I'm the executive director for Ingleside on the Bay Coastal Watch Association. Today, I would like to bring forward concerns about the decrease in our air and water quality I have witnessed since living in Ingleside on the Bay over the past 5 years. Here in the Coastal Bend, TCEQ has only one ambient air monitor located in Nueces County. This air monitor is miles across the Corpus Christi Bay from San Patricio County, and not even in the direct wind path of polluting industry emissions where I live. There has been increased industrialization in San Patricio County over the past few years, so much so that on one side of Ingleside on the Bay is the, and I quote, the #1 LNG exporter for the entire United States. On the other side of Ingleside on the Bay is the #1 and #2 crude oil exporters for the entire United States. Then when you add in the third crude oil exporter, also right next to these other two, they make up for 60% of all of the crude oil exported for the entire United States. All of this less than a mile from my home. So how much industry is enough? There are days when the air is so bad my family cannot go outside because it will give them a headache. There are times in the fall when we would like to take advantage of our cool coastal breezes and have the windows open, but we cannot because the pollution coming from the southeasterly winds from these refineries directly towards our home is so bad, we have to shut the windows immediately and sometimes even put towels under the doors. Complaints are filed by us and other community residents, but yet the TCEQ's mobile air monitoring unit takes hours to arrive and seems to always consistently miss the events. My family and residents here would like to know what it's going to take for us to receive air monitors here in San Patricio County to ensure our right for clean air and ensure our children and families are safe and healthy. Thank you.
Thank you, Ms. Valdez. And before we go to the next commenter, I'll be careful to follow our general counsel's admonitions and stay within the bounds of facts and policy. But responding to the question about air monitors, we annually update our stationary air monitoring plan. That's done consistent with federal requirements. We have hundreds of monitoring sites across the state and many hundreds of samplers across the state, with multiple samplers being located at each site. The state of Texas has a stationary air monitoring network that goes well beyond the federal requirements. But I understand your point, and it's easy to understand. It's a common one that even with all that, Texas doesn't have enough. It's a common and understandable sentiment. But But even with all of our federally required monitors and all of the monitors that the state has supplied voluntarily above and beyond those required monitors, we're operating with a finite budget. So I just wanted to provide that context and let you know that the folks who work on our stationary air monitors and the annual plan will hear these comments. I think they're probably listening now, but if not, we'll make sure that they hear these comments. So we appreciate you you sharing your thoughts with us today. Ms. Smith?
Peter Bella.
Mr. Bella?
Good morning.
Good morning. Go ahead, sir. Whoops. We may have lost you. Do you want to check your mute button?
Let's try again.
Okay, we hear you. Go ahead, sir.
Just so the organizer doesn't unmute mute me again. Thank you. Okay. Good morning, commissioners. My name is Peter Bella. I'm in San Antonio and speaking on my own behalf. I'll comment that I appreciate Mr. Cooper's comments from Houston on item 55. My comments regarding input to TCQ are aligned. The TCQ must conduct a full environmental impact statement on every major air and water quality permit. Given more time, I would focus on the industrial build-out of the Texas coast to enable the oil and gas, plastics, and other industries to grow, which build-out includes enabling polluting industries such as desalination to grow, and then to put at risk local communities through their operation. I have recently read that, for instance, crypto mining is creating an environmental crisis for Black Texas communities because energy companies are planning to build new fossil fuel plants in communities of color to meet the demands of crypto mining. While I understand the energy crisis that has caused ERCOT to assess a likelihood of a 16% chance of grid emergency during evenings this August, TCQ must be vigilant to be sure that all Texans are protected. Conducting a full comprehensive EIS on every major air and water permit to include the complex existing environmental considerations in our communities moves the state in the right direction. I appreciate Ms. Cindy Valdez's comments. In this vein, I would also encourage the commission to adopt that public comment should be set for a specified time of day, perhaps at the 2-hour mark after the meeting commences, or as item 1 on posted agendas, to facilitate further engagement by citizens. Thank you very much.
Thank you, Mr. Bella.
Ms. Beatriz Alvarado.
Ms. Alvarado? Yes, please. Good morning. I'll have you check the mic and make sure that you have your light turned on there.
Yes.
Okay, we hear you loud and clear. Thanks for being with us. Go ahead when you're ready.
Okay. Okay, I'm ready to go. My name is Beatriz Alvarado. I am the water organizer for Texas Campaign for the Environment. I live in Corpus Christi, Texas, where they're trying to build the first large-scale seawater desalination plant in the world in a closed-based system. I'm neighbor to Valero, Flint Hills, Lyondell-Basell, Citgo, and other climate crisis culprits who belong to the Affordable Water for Corpus Christi Coalition. Not sure if you're familiar. This is the coalition using state law to their advantage to appeal higher water rates that our city council is trying to impose. They're not only trying to force us to continue to subsidize their water use, they're trying to sacrifice our bay to fulfill contract obligations that only an agency like the TCEQ can stop. I'm here to publicly lament how useless this agency has been in helping us achieve any semblance of justice down there. I'm here because the commission discourages public comment by not only allowing comment once per month and setting the time for receiving comments as the final item listed on the agenda. Public comment should be set for a specific time of day, maybe at the 2-hour mark after the meeting commences, as item 1 on posted agendas. I'm here because of this commission's consistent failure to adhere to SOA's recommendations to deny permits. I'm here because the commission presumptively considers all permits as minor and not major.
I'm here because the commission improperly excludes numerous impacted classes of folks by restricting affected person status. I'm here because the commission routinely allows facilities to amend original air quality permits, at times multiple amendments, when a facility can't meet original emission limits. I'm here because original permits are consistently viewed as estimates of emissions, and those estimates are routinely increased when operations commence. Once emission standards are calculated in the original permit, facilities should be required to implement maximum control technology to remain within original limits or shut that part of the operation down, or at least fine them. I'm here because violations that become the subject of enforcement proceedings are later routinely included as allowable deviations in subsequent permits. I'm here because burden of proof should always remain with the applicant for the permit. It should never shift to the person protesting. I'm here because once an NAPD is published, all application materials and permit file memos must be made easily accessible to the public without the need for a PIA request. I'm here because plant-wide applicability limits avoid new source review. I'm here because Tier 2 anti-degradation reviews should be the standard for water quality permits, allowing for a full assessment of economic and social impacts.
That's time.
Thank you for your
Go ahead
time.
and finish your thoughts.
I'm here because the TCEQ must conduct a full environmental impact statement on every major air and water quality permit. I'm here because the TCEQ should discourage speculative permits by proactively canceling permits that have not been used within 2 years. Please do better. Thank you for your time.
Thank you, Ms. Alvarado. Appreciate you being here.
Ms. Kathy Fulton.
Ms. Fulton, are you there? Ms. Fulton?
Hello?
Oh, we hear you now. Yes, go ahead and state your name for the record, and then the floor is yours.
Thank you. Yes, my name is Kathy Fulton, and I live in Port Aransas, Texas. I'm part of Port Aransas Conservancy along with some other groups. And there's way too much to say. I'm not going to be as eloquent as Beatrice just was, but just this meeting alone has got my blood boiling. And so I want to just point out that, like some other people did, your public comment that y'all fail to encourage. And just to be clear, this year in public comment, three people for public comment. Now, why is that? You already know the answers to these because you put it at the bottom of the dang agendas. So, if you really want public participation, which I do not believe you do, keep it where it is or move it up, change it up. Okay. But the main thing I'm going to focus on right now is the whole thing with three people sit on this commission, 3 appointed people sit on this commission. And you never ask questions during these proposals for decision that are always at the beginning of the meetings. No question. You always say, is there any questions? And no one ever has any questions for the ED, protestants, or OPIC. Now, again, why is that? I think it's because we just don't want to discuss this stuff in public. And I'm going to give you some good examples of things recently that were not discussed in public, Chairman Neerman. Wichita Falls, this was back in May. The ALJs recommended denial, or at least recommended proposed alternatives to that, along with OPIC. And then the commission just rejected it, rewrote the ALJ stuff, and approved it. Valero, back in April. This was a big deal. And I'm sorry, sir, you, I believe, rewrote all that, presented it to everybody. And I would go so far as to say I believe open meetings issues might have been violated, but it behooves me to think 3 people sitting on actually what is one of the most powerful authorities of the state of Texas can just override the ALJs when everybody that goes through these hearings, which I have been through 2 of these hearings, and they are no cakewalk. And yet y'all just reject it, do what you want. You just say, oh, none of that matters. We're just gonna say no, rewrite the whole proposal for decision, and here we go. Or when there's like major violations, say in all of these air contaminants, say from Cheniere, that's a big one. And also from Buckeye Partners here, that of course, that one was a couple of years ago, but it was on your agenda back in November of last year. And they get a dippy little penalty, but
That's time.
the way that the problem was solved was to allow increases in air emissions. Same is true for Cheniere, over 200 increases allowed. This is what's got to change. Thank you.
Okay. Thank you, Ms. Fulton. Appreciate your comments.
Patrick Nye.
Mr. Nye, are you with us?
Yes, can you hear me okay?
We can. Go ahead, sir.
Thank you. Patrick Nye, Ingleside on the Bay, Coastal Watch Association president. And thank you for the time to address the commission. I look at the commission's mission statement and to protect our public health and so forth. And the goal is to clean air, clean water, and safe management. But I think y'all have lacked in being that is a priority. And it seems that the priority is gifting industries with permits that are harmful to people in our environment. It's not about protecting the public. The commission improperly excludes the public health impacts by restricting the affected person's status. Air and water pollutants, once released, are not restricted to 1 mile, 3 miles, or even 10-mile radius. Yet the TCEQ creates an invisible barrier to the public's right to qualify as an affected person. The commission should prioritize health studies for not only San Patricio County that sees a huge industrial growth, but also other counties that are affected by this. And perhaps enforcing permits and utilizing the penalties would be used for the air monitoring and other health studies, since the commission does not have monies available. One of the big factors here in our area is that the TCEQ allowed for the splitting of facilities in favor of increased emissions for the permit limits. And this fact is well documented. An example of this in our area is that an oil terminal was disallowed the splitting by TCEQ staff twice. But on the third effort by this company, utilizing a well-known lobbyist, succeeded in approving the splitting of this facility. This action by the TCEQ doesn't appear to be protecting the public's health, and instead increases the economic bottom line for the facility, in conflict to the goal of clean air. Along the same lines, the commission ignores cumulative impacts of a facility, even when the emission sources stand side by side. The TCEQ must conduct full EIS on every major air and water quality permit. That is the minor thing, the minimum thing that you should do. You should also not consider all permits as minor, as it seems that is the case in most areas that you are approving these permits, even when the evidence shows the permit is clearly not minor. Air monitoring modeling, as we pointed out, are miles away from the permit locations here in San Patricio County. We don't have an air monitor within the entire county. And when the commission commits to the safe management of waste with reliable and air quality scientific data, where is that data? It's miles away is not helping those people that are nearby. I also want to say that the commission routinely allows facilities to amend original air quality permits, at times
Next time.
multiple permits. And as these as-built permits roll out, the aggregated emissions continue to flow. Thank you for your time.
Thank you, Mr. Nye. I appreciate your comments. Let's go back to Mr. Summerlin. Are you there, sir? Mr. Summerlin? All right, we tried. I think, is that it, Ms. Smith?
Can you hear me?
Oh, hey, great. Yes, we can. Go ahead and introduce yourself, and then the floor is yours, Mr. Summerlin.
Okay, yeah, I'm sorry. I've been switching between mics. Can you hear me now?
Yeah, that's all right. We're glad to have you, and you're coming in
All
loud and
right.
clear.
All right. Thank you very much, Commissioner. Good morning. My name is Errol Summerlin. I'm currently relocating to Maryland, state of Maryland, but I still have a home of 40 years in Portland, Texas. I'm also co-founder of CAPE, the Coastal Alliance to Protect Our Environment. Some like to label us as radical environmentalists, and there are probably some of those in our midst. But when it comes down to it, individual members of this alliance come from all walks of life. We're Republican, Democrat, and Independent. We are school teachers and professors, engineers, roughnecks, and retired oil and gas executives. We're geologists and former urban planners. We are retirees and young professionals. In essence, our lives and life experiences span the spectrum of the workforce that drives our economy and our future. Organizational members of CAPE are newly formed grassroots groups, upset with what's going on, and longstanding allies of the environment and wildlife. If you'd like to learn more about us, follow us at capetx.com. I want to thank you for the opportunity to speak today. Item number 57 itself is what I'd like to address. I think it most important that you hear from residents who are impacted by the decisions you make. Impacts to their daily lives caused by increasing encroachment of industrial development, impacts to their short and long-term physical health, and in the coastal bend, the impact of industrial water demand on our ecosystem and our economies that rely on a healthy base system. I don't think you're hearing enough from folks. There's a lot of unrest amongst the public in the coastal bend, unrest with the massive build-out plan for the area, an enormous expansion of LNG, increasing vessel traffic, carbon capture and sequestration, ammonia and hydrogen facilities by the dozens are vying to locate in our local communities. I suspect there are a number of local leaders that are uneasy about all this as well. So you need to hear from the public more frequently. Currently, as best I can tell, you only receive public comment once per month. That needs to change. You should allow public comment at all meetings of the commission. In addition, you need to set a specific time for receiving public comment. Make it at the beginning of an agenda, at noon, at 5. You set the time, suspend regular business to receive comment. It's an easy accommodation. You may not like everything you hear, but look at it this way. If we get too loud, industry will come and shower you with accolades. Fair enough. We just want a meaningful opportunity to speak to you about our lives and the impacts of your decisions in the coastal bend, even if just 3 minutes. Thank you very much for your time.
Thank you very much, Mr. Summerlin. We appreciate your comments. Thanks for being with us today. Anyone else?
That's our entire list.
Okay. In that case, I'll ask you to please call the next items.
Okay, the commission will be meeting in closed session in room 242.
Oh, I'm sorry, ma'am. Why don't you come up here and
Apologize for interrupting.
yeah, no, well,
thank you for
I'm glad you did.
interrupting.
We had a communication breakdown
Thank you,
somehow.
I appreciate it.
And is the light on that?
Yes.
Mike?
thank you.
Okay, and we can hear you. So go ahead and introduce yourself and
yeah.
then the floor is
Good
yours.
afternoon. My name is Autumn Hensick Fain, and I also traveled here today from my hometown of Corpus Christi, Texas, in order to have the chance to speak to you all directly about some concerns that I have regarding TCEQ's lack of oversight in my home. The opportunities that we're given to make our voices heard, to look at you all in the eyes are pretty far and few between. So I wanted to make sure to be able to come today. I believe that a full cumulative impacts assessment should be performed before any further expansion in Nueces or San Patricio County is allowed. That's the county I live and was born and raised in, and our neighboring county right next door. Seeing as industries continue to expand with no regard given for the damage that they're already causing to my home, there's just so many individual permits that are obviously intended to distort, to hide the total cumulative emissions and environmental impacts, yet there's industries like Cheniere, one of my neighbors, that, want more and more and more. In fact, I wanted to state today as well, I'm one of almost 500 community members in Nueces and San Patricio County who have been diligently emailing and sending handwritten letters into Cheniere's CEO Jack Fusco's inboxes with no response, pleading with him to consider swapping toxic gas combustion turbines that they currently use at their Gregory site, which emit benzene and formaldehyde. Like, these are two known carcinogens that are in the air I breathe every day. Cheniere's self-controlled, self-reported air quality data is a joke. As I believe Ms. Valdez stated, there are not TCEQ air monitors in Gregory, Texas, where Cheniere is located. The averaging of their daily emissions just provides a really inaccurate depiction of the harm that they're doing to us down there. I wanted to come here today because the commission does tend to ignore those cumulative impacts of a facility, even like Mr. Nice stated, when those emission sources stand side by side, which is so much of what we see in Nueces and San Pat. I also wanted to come today because so many of my friends and allies are still navigating damage that they have to their homes after Tropical Storm Alberto. And I wanted to express my absolute disdain with the commission's decision to still hold a hearing regarding Cheniere's air permit on June 20th. Y'all, we were in a declared state of emergency by our mayor, by Governor Abbott. I drove to that hearing and watched folks being rescued by the National Guard, and TCEQ still decided to hold that hearing. So in the same vein that, a lot of us are asking for more opportunities to make our voices heard, to make these comments, please consider what we are experiencing, what we are living in and day out when you hold these hearings as well. Thank you very much for your time.
Thank you. Appreciate your comments. Thanks for making the trip to Austin. Is there anybody else in the room or online with us virtually who'd like to offer a comment? Okay, hearing none, seeing none, I think we're done with this item. Ms. Smith, why don't you go ahead and call the next items?
Okay, the commission will be meeting in closed session in room 242 in this building, beginning, should we say 11:45? Give people 5 minutes. As permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 551.074, to take up and consider matters pursuant to items 58 through 61 as posted and noticed.
The time is 11:40 a.m. We are in recess.
The commission met in room 242 of the Texas Workforce Commission for closed session from 11:45 a.m. until 12:17 p.m. on item number 58 as posted and noticed. Pursuant to Texas Government Code Section 551.074, no action was taken. This agenda stands adjourned and the time is 12:23.